lawyer Sean Williams, and we are also going to ask Mr. Williams to address you as well.
Camera down, please. Thank you.
So we have decided to issue warrants in this case today. I have with me copies of the warrants, and after my presentation, we will let you know how you can get copies of the warrants today. So the question is asked, why were we able to charge this case now? So I want to explain that we have already had an opportunity to speak with 3 of the witnesses in this case, and those are the 3 witnesses who were from West Memphis, Tennessee. We have had an opportunity to conduct interviews with 7 other witnesses other than the 3 witnesses from Tennessee. We've also had an opportunity to view
Back a little bit.
Yeah.
Sir, can you push it?
So we have had an opportunity to review 8 videotapes, 2 Atlanta body cam tapes, 2 Atlanta Police Department dash cam tapes. We have also had an opportunity to review a Wendy's surveillance tape. We have also viewed 3 citizens' cell phone videos. With many of the videos, we had the opportunity to enhance the videos so that we could get a better look. The other thing that we have had an opportunity to do is to view some of the physical evidence. The Chevrolet Trailblazer was a vehicle that was in the line at Wendy's on the night of this incident, and it received a shot from Officer Rolf's gun. We've had an opportunity, along with the GBI now, to view that Trailblazer. My office has had an opportunity to inspect the crime scene. We have conducted a canvass of the area. We started our investigation at about 1:15 a.m. Saturday morning, and we have been working on this case around the clock since that time. We have spent some time examining the taser evidence in this case. We've actually examined and possessed the 2 tasers that were used. We have also had an opportunity to examine the taser logs that are prepared as the tasers are used. And we have also consulted with a taser expert from the company that manufactures the tasers. We received a preliminary medical autopsy. We've received a preliminary ballistics report, and in reaching our conclusions today, we have worked with both the Georgia Bureau of Investigation as well as the Atlanta Police Department. This will be the 4th time that we have asked that arrest warrants are issued in a case before an indictment. This lists the other 3 cases that we were involved with where an arrest warrant was issued prior to indictment. Unfortunately, this marks the 40th prosecution of police officers for misconduct here in our county, and this is the 9th time that we prosecuted a homicide case committed by a police officer. 8 of those cases involved black males, and 1 of those cases involved a black female. So in reaching our decision, there were some considerations that we considered important. And one of the things that we noted from our evaluation was that Mr. Brooks, on the night of this incident, was calm, he was cordial, and really displayed a cooperative nature. Secondly, even though Mr. Brooks was slightly impaired, his demeanor during this incident was almost jovial. Also, we noted that he received many instructions from the Atlanta officers, and he was asked many questions. Some of the questions he was asked repeatedly, but for 41 minutes and 17 seconds, he followed every instruction, he answered the questions. The fourth thing we noted is that Mr. Brooks was never informed that he was under arrest for driving under the influence. And this is a requirement of the Atlanta Police Department when one is charged with DUI. The Atlanta Police Department's own procedures require that that person is informed immediately that they are under arrest. And then he was grabbed from the rear by Officer Rolf, who made an attempt to physically restrain him after the 41-minute and 17-second discussion. We concluded and considered it as one of our important considerations that Mr. Brooks never presented himself as a threat. At the very beginning, he was peacefully sleeping in his car. After he was awakened by the officer, he was cooperative, and he was directed to move his car to another location. He calmly moved his car. Mr. Brooks was asked whether or not he had a weapon. He indicated that he did not. Without any resistance, he passed his driver's license to the officers, and the officers then asked Mr. Brooks whether or not he would consent to a pat-down or a body search, and Mr. Brooks allowed them to search him, and the search yielded no weapon. We found that it was of interest that when the officers patted Mr. Brooks down, they noticed there was a bulge in his pants. They did not pull that item out of his pocket. They took Mr. Brooks's word that that bulge represented a number of dollar bills. But Mr. Brooks never displayed any aggressive behavior during the 41 minutes and 17 seconds. Now, this is another important consideration that we discovered as we evaluated this case. Once Mr. Brooks was shot, there is an Atlanta policy that requires that the officers have to provide timely medical attention to Mr. Brooks or to anyone who is injured. But after Mr. Brooks was shot, for some period of 2 minutes and 12 seconds, there was no medical attention applied to Mr. Brooks. But when we examined the videotape and in our discussions with witnesses, what we discovered is during the 2 minutes and 12 seconds that Officer Rolf actually kicked Mr. Brooks while he laid on the ground, while he was there fighting for his life. Secondly, from the videotape, we were able to see that the other officer, Officer Brosnan, actually stood on Mr. Brooks's shoulders while he was there struggling for his life. We were able to conclude that based on the way that these officers conducted themselves while Mr. Brooks was lying there, that the demeanor of the officers immediately after the shooting did not reflect any fear or danger of Mr. Brooks, but their actions really reflected other kinds of emotions. So as we are drawing our legal conclusion in this case, we were led by the two foundational cases in this matter, one being Tennessee versus Garner. And what that case points out is when an officer is pursuing a fleeing suspect, that the officer may not use deadly force to prevent escape unless the officer has probable cause to believe that the suspect poses an immediate threat of death or of serious physical injury to that officer. The next foundational case that we used in our analysis is Graham versus Connor, which says that this test is based upon that of a reasonable officer on the scene and not the individual officer, but a reasonable officer on the scene. We've concluded at the time Mr. Brooks was shot that he did not pose an immediate threat of death or serious physical injury to the officer or officers. If you would get the photograph, the tasering. This is the first photograph that we were able to clean this kind of crooked to see if you can get a straight one. What this photograph illustrates is the point that Officer Rolf at this point was firing a taser, and this is Mr. Brooks, who was firing a taser as well, but I don't know if you can see it clearly. The prongs from the table, the taser, were actually fired above Officer Rolf's head. I'd like for you to also look at the position of Officer Rolf and Mr. Brooks, that they are here next to this red automobile. If we look at the next photograph,
Thank you.
if we look at the next photograph, we'll see that the positions of both parties, they've changed. Mr. Brooks has now moved away from his original position, and we estimate the distance is probably about 12 feet. And Officer Rolf has moved about 10 feet from the position in what is our exhibit number 1. This second video or second still shows the very instance that the shot was fired into the back of Mr. Brooks. And we have also calculated the distance, and the distance that they are apart at that time was 18 feet 3 inches at the time that this shot was fired. So based upon that information, we have concluded that Mr. Brooks was running away at the time that the shot was fired. Mr. Brooks was shot twice in the back. One of the shots was a center shot to the back that penetrated his heart, and it was done by a 9mm Glock. Now, one of the things that we also relied upon in our conclusion is something that is called under the law, referred to as an excited utterance. And that's when someone makes an immediate statement, and because it is made without the ability to consult with counsel or to think about it, under the law, an excited utterance is considered as highly reliable. And at the time that the shot was fired, the utterance made by Officer Rolf was, "I got him." That was the statement that was made at that time. We also noted that Officer Rolf was firing a taser at Mr. Brooks. The City of Atlanta SOPs, in fact, prohibit officers from firing tasers at someone who is running away. So the City of Atlanta says you cannot even fire a taser at someone who is running away. So you certainly can't fire a gun, a handgun, at someone who is running away. So in addition to our findings, as many of you all already know, that the Atlanta mayor, Mayor Keisha Bottoms, and the police department concluded that Officer Rolf's actions were excessive and in violation of APD's SOP. There's an SOP, I believe it's 4.1.1, and after their analysis that the actions were excessive, Officer Rolf was fired. We have also concluded that Rolf was aware that the taser in Brooks's possession, that it was fired twice. And once it's fired twice, it presented no danger to him or to any other persons. Now, we have had something quite remarkable to happen in this case, and it involves the testimony of the other officer, Devin Brosnan, because Officer Brosnan has now become a state's witness. He has decided to testify on behalf of the state in this case. What he has said to us, that is within a matter of days, he plans to make a statement regarding the culpability of Officer Rolf. But he indicated that he is not psychologically willing to give that statement today. Officer Brosnan, however, has admitted that he was in fact standing on Mr. Brooks's body immediately after the shooting. So these are the charges that we have had filed today, signed by one of our Superior Court judges. These are the 11 charges against Officer Rolf. The first charge is felony murder. This is the death that is as a result of a underlying felony, and in this case, the underlying felony is aggravated assault with a deadly weapon, and the possible sentences for a felony murder conviction would be life, life without parole, or the death penalty. Now, he's also charged in the arrest warrant with aggravated assault with a deadly weapon, and this is a count charging him for the shooting of Mr. Brooks, and the possible sentence for aggravated assault is 1 to 20 years. The third aggravated assault account is for the shooting towards or in the direction of Mr. Melvin Evans. Mr. Evans was the person who was seated in the car. We have the picture of this. Okay. And if you would point out, this automobile is the place that Mr. Evans and his two companions were driving, and a shot was fired. And I believe we've also got a photo of the shot that ended up in the vehicle. I think you gotta stand it up. And so with count 4 against Miss Officer Rolf, it charges him with aggravated assault for firing the weapon in or in the direction of Danielle Killians, who was in the passenger side of the front seat of the car. Next slide. Count 5 is an aggravated assault charge, and this was a charge for shooting towards or in the direction of Michael Perkins. Mr. Perkins was seated in the rear of this same vehicle at that time. There's a charge for criminal damage for shooting into that vehicle. Also, Officer Rolf is charged with 7 violations of office. Each one of those carries a 1 to 5 sentence. These are violations of his oath of office for the city of Atlanta, arresting Mr. Brooks for the DUI without immediately informing him of the arrests, shooting a taser at Mr. Brooks while he was running away, which again is a violation of Atlanta's own SOP. Thirdly, excessive force when shooting a firearm at Mr. Brooks. And number 4 is the failure to render timely medical aid. Those are the 4 violations of oath. The 8th is for kicking Mr. Brooks, and the possible sentence for kicking Mr. Brooks is from 1 to 20 years. And we actually have a photograph of the and if you would go to the next one. And these are the charges for Officer Brosnan, and there are a total of 3 charges. And the first charge is for aggravated assault, and this is for standing or stepping on Mr. Brooks's shoulder. The possible sentence for this crime is 1 to 20 years. And this is a photograph of Officer Brosnan, who you can see to the right. And at the time of the photograph, he is standing on the body of Mr. Brooks. And as I've indicated earlier in our conversations with Officer Brosnan, he has admitted that he stood on the body of Mr. Brooks. He said he believes that he was standing on Mr. Brooks's arm, but that is what the photograph shows. We've also charged him with additionally 2 violations of oath. One is for the standing on the shoulder. That is an unauthorized weaponless control technique which the city of Atlanta prohibits. And the second violation of oath was for the failure to render timely medical aid to Mr. Brooks. Let's see. So the arrest warrants have already been signed. We are asking Officer Rolf and Officer Brosnan to surrender themselves by 6 p.m. on tomorrow. Because Officer Brosnan is now becoming a cooperating witness for the state, we are asking the court to grant a bond of $50,000 and to allow Mr. Officer Brosnan to sign that bond. As I indicated, that he would become one of the first police officers to actually indicate that he is willing to testify against someone in his own department. As for Officer Rolf, the person who fired the 2 bullets, we're recommending no bond for Officer Rolf. If he is given a bond. That would be done by one of our Superior Court judges, but because of the severity of his act and then following up that act with kicking Mr. Brooks, we're asking that he not be granted a bond. I think that's it. I do want to ask Mr. Sean Williams. Mr. Williams represents Melvin Evans, who was driving the vehicle from Memphis. I have already apologized to Mr. Evans on behalf of the people of Fulton County and the city of Atlanta. He was only down here for a short while, and it's really unfortunate that he was, his vehicle was fired upon that night. Sean.
Thank you, Mr. Howard. I first want to, on behalf of all three of my clients who...
Well, just when you think it couldn't have gotten any worse, learning the details of how Rayshard Brooks was allegedly murdered by police, we learned some very chilling details from the Fulton County District Attorney, Paul Howard. I want to bring in CBS News Chief Justice and Homeland Security Correspondent Jeff Pegues, who has been covering this case from the beginning. I know earlier this week sat with the District Attorney and spoke with him. And Jeff, we have 11 charges against the first officer, Rolf, including felony murder, additional charges of aggravated assault, not only against Mr. Brooks, but of course some others who may have been shot, could have been shot, I should say, as well as the violation of oath and aggravated assault. And Jeff, the picture that just really hit me was even after he was on the ground, shot twice in the back, him kicking him. Jeff?
Yeah, this was an extraordinary press conference. We usually don't hear a DA outlining all of this evidence in a press conference before there's been an arraignment. And so that's what we have here. And what Paul Howard is clearly trying to do is appeal to the masses, people who might say, well, did the officer feel like he was in danger? Well, does the DA have enough evidence? Well, he had pictures, he had video evidence, he has statements from the officers, and in fact, he announced that he got one of the officers to flip against Officer Rolf. And so we rarely see this kind of detail in a press conference where a DA announces charges. But that's what we saw here, in part because of all this evidence that they have. And then you have the 11 charges against Officer Rolf. Why? Perhaps because the DA doesn't want to miss on this case. He wants to make sure that he gets a conviction. So he could have gone with fewer charges, certainly, but he threw as many charges at Officer Rolf as he could, and then played to the audience that was watching there with all of the pictures sort of laying out what will be a strategy at trial.
And as you mentioned, Officer Brosnan has now turned a state's witness against his fellow officer there. Also, the district attorney making clear that for 41 minutes, Mr. Brooks was not a threat, in their words, that he was cooperating. He was never informed of his potential DUI arrest, and that the district attorney has 8 videotapes in its possession with all of this evidence. Our coverage will continue on our 24-hour streaming network, CBSN, and you can watch it at cbsnews.com or on our CBS News app. There will be much more on your local news on this CBS station and a full wrap-up tonight on the CBS Evening News. This has been a CBS News